Thank you. It's a real pleasure to be here. I've never been at the University of Washington before, so you have a beautiful institution and a great location here in Seattle. So thank you for inviting me to talk to you today about gene patents. So what I'd like to cover today is, first of all, talk to you about what patents are and specifically what gene patents are, and then talk to you about my personal experiences with gene patent enforcement or license enforcement as a director of molecular pathology, but mostly at the University of Pennsylvania, and talk about the medical significance of gene patents, and then talk about potential solutions to the problems that I will be describing to you. So patents are established by the U.S. Constitution, so they go right back to the beginning of the United States, and patents grant to the patent holder the rights to exclude others from using their patented invention for a limited time. And something that is patented has to be made by man, it has to be new, non-obvious, and useful. And it cannot be a product of nature or a basic principle or a natural phenomenon. So you can't patent E equals mc squared, you can't patent gravity, and those kinds of things just are not patentable. So the purpose of a patent is to promote the progress of science and useful arts. So it provides an incentive to invent, because if you invent and get a patent, then you're protected. Your invention is protected for you to use only, or anyone that you want to use it, you can use it. It also promotes the disclosure of this invention so that other people can know about it. Even if they can't use it, then they might want permission to use it, and so it discloses information. And it provides incentive and protection for commercialization. So that means that back in the U.S. Constitution days, there weren't venture capitalists, I don't think. But venture capital is very interested in what is protected, so you know that you don't get scooped by someone else and their investment is wasted. So how did we get from the patent rights granted in the U.S. Constitution to the patenting of human gene sequences? And I'd like to acknowledge my colleague Roger Klein, who is also active in the Association for Molecular Pathology and is a physician as well as a lawyer, for much of this background that I have hijacked from watching one of his talks. So in the 1970s, we were plagued with high unemployment, high inflation, rising oil prices, similar to what we've recently experienced, and shaken U.S. confidence in the economy, much like we're experiencing today. And there was a period of increased biotechnology funding. So this green line here, back in the 1970s, it's buried down here, but you can see that it is rising through the 70s, into the 80s, and then starts to take off. Well, this is the NIH biomedical research funding that begins to take off in the 70s and 80s. Well, in 1980, there was an act introduced into Congress. It's called the Bayh-Dole Act. So before this act was introduced in 1980, there were about 28,000 patents that had been funded, the research for which had been funded by the United States government, and less than 5% of these patents were licensed for commercialization. So Bayh and Dole, Birch Bayh and Bob Dole were two senators who introduced the Bayh-Dole Act that would allow nonprofits such as the University of Washington, Weill Cornell Medical College, and small businesses to retain the patents from the research that their employees or faculty did. So universities were then encouraged to license their patents. They got to hold on to their patents and to license these to businesses for development of the inventions. So after Bayh-Dole, academic patenting increased dramatically. There were about 2,200 companies that were founded based on academic patents, about $30 billion worth of activity each year, providing about 250,000 jobs, and more than 1,000 products based on university licensed discoveries. And this really created a change in the scientific environment at universities from a publish or perish, we're doing it for the good of patients kind of attitude to let's make money for the university, or at least that was the university leadership attitude that patents could be for significant monetary gain, not only for the universities, but also for the individual inventors and their departments. And so what you see is almost no patents early on, and then it just, after Bayh-Dole, it starts to soar, the number of patents that are held by universities. And then we move on to a case called Diamond versus Chakrabarti. So Anand Chakrabarti was a scientist who genetically engineered a Pseudomonas to be able to digest oil. And so this Pseudomonas had new enzymes put into it that, when introduced into oil slicks, could digest the oil that couldn't be cleaned up mechanically. And so he filed a patent application in 1971, and the original patent application for this Pseudomonas organism was denied because it was felt that living things were not patentable. And it was appealed to the Patent Office Board of Appeals, and again denied, and taken all the way to the Supreme Court. And in a 5-4 decision, they found in favor of Chakrabarti, and this engineered Pseudomonas organism was allowed to be patented in 1980, right along the time that the Bayh-Dole Act was enacted into law. So basically, after Chakrabarti, you had patenting of a Harvard mouse, leukemia-derived cell lines, stem cells, and then leading on to human gene sequences that were allowed to be patented. So when human gene sequences are patented, they aren't patented as the sequences that are in our bodies. They're patented as isolated chemical substances. And there were precedents for patenting purified, naturally occurring products such as epinephrine and vitamin B12 that had been patented. And so what is patented are isolated and purified, separated from all the proteins, gene sequences, sometimes as the gene sequence itself, sometimes as a cDNA or a complementary DNA copy without introns, for those of you who know molecular biology. But it's the actual gene sequences that were patented. Human gene patents very often claim the correlation between a gene sequence or variants in a particular gene sequence and a disease or disease risk. And many of these patents will claim every single known and potentially yet to come method for looking at the sequence of that DNA region, including many of the methods that we use in the clinical laboratory to do diagnostic testing. It's not clear with these patents what has been made by man as required by the US Constitution, but these patents do basically permit monopolization of discrete medical information and ownership of that medical information. Right now, about 20% of genes are covered by one or more patents. That's in the entire human genome of 20 to 25,000 genes. Half of the genes known to be involved in cancer are patented, and one company alone, Incyte, holds patents on about 10% of all human genes. And these are some examples: like breast cancer, Canavan disease, colon cancer, hearing, deafness genes, a wide variety of very important medically important genes are already patented. So that's the patent situation and what has been patented of the human genome. So what have my personal experiences been? And I'm sure John Tate could tell his own experiences, but I'm a molecular pathologist, and my medical training is in pathology. I have a PhD in molecular biology, and I understand the use, performance, and interpretation of laboratory tests for genetic or molecular biology-based diseases. And I translate genetic and genomic science into diagnostic tests that are used clinically. These tests are used to direct and enhance patient care, and I want to make sure everybody's clear that this is my medical practice. This is not my research, although I sometimes correlate on research branches that come off of this. And I experienced gene patent enforcements at the University of Pennsylvania. So this is one of the letters I received from Athena Diagnostics. Remember that name, you'll hear it again, in 1997. And this was, Athena Diagnostics had acquired exclusive rights for a patent number 5508167 that covered the ApoE4 allele and was related to late onset or prediction of late onset Alzheimer's disease. And it was only by using Athena's facilities that I could have this testing done at $195 a test. At the current time, the University of Pennsylvania was charging $100.50 for this test. So this is one of the problems with a sole provider. They can charge whatever price they want for the testing, and there's no competition and no second opinions. This is a second letter, so that one was in 1997. This one is in 1998 from SmithKline Beecham that held patents for hereditary hemochromatosis testing, which is an iron overload storage disease. And this was covered by 3 different patents, and they held exclusive license to these patents. And they requested that I make the necessary arrangements to be able to continue to do this testing, which consisted of a $25,000 upfront fee, or they were willing to bargain for any intellectual property licenses that the University of Pennsylvania might have that they could exclusively license, and then a fee per test for doing this. And when I went to my vice chair, because I wasn't vice chair for laboratory medicine at the University of Pennsylvania, he laughed hysterically at $25,000 upfront fee. And so basically we didn't do that. Again in 1998, and this is again Athena Diagnostics, enforcing one of their patents to spinocerebellar ataxia type 1, or SCA1. John is grinning. And Athena has exclusively licensed this patent, and it's only by using Athena's facilities. The price isn't here, but this points out a different issue with a single gene being held by a single provider for testing, and that is that spinocerebellar ataxia type 1 is basically one of the genes that causes the clinical syndrome of spinocerebellar ataxia. And now there are 29 or more genes, and if you do this testing, you don't know which of these genes is causing the disease in a particular patient. So if you can't do SCA testing for SCA1 gene, then it's not logical for you to do the testing at all because you're missing one of the major genes in this set. So you have to, at the time, we were doing testing for SCA1, 2, 3, 6, and 7. And so to take SCA1 out of this basically means that you're shutting down a laboratory from doing SCA testing. Now, John informed me today that he was very adamant and has basically stymied Athena Diagnostics from enforcing against University of Washington. So he was more creative than I was. This is an experience that I had with Miami Children's Hospital Research Institute, who held the patent for Canavan disease. And they wanted to charge $12.50 per test. And they wanted to also set volume restrictions on the number of tests that I could do per year. So what you're seeing here is a pattern of a gene patent holder or exclusive licensee of a patent basically can do whatever they want with this information. They have the ability to control it in whatever way they want to. Now, Canavan disease, this is another example similar to SCA, but the American College of Obstetricians and Gynecologists recommends Canavan screening for all Jewish women. And it's part of what we call a Jewish panel. The Ashkenazi Jewish ethnic background patients are at higher risk for certain genetic diseases, Canavan, Tay-Sachs, Niemann-Pick, CF, and so you can do a screening panel. Again, if you can't do this Canavan screening, then you don't do any of the Jewish panel screening. Now, this was a lab. It was the laboratory in the Department of Medical Genetics at the University of Pennsylvania, and Arupa Ganguly was doing BRCA1 mutation testing that correlates with increased breast cancer risk. And Myriad Genetics is the patent holder and exclusive licensee of the BRCA1 patent, and they are the exclusive provider of full BRCA1 gene screening in the United States. This also captures BRCA2 testing, since you do generally both at the same time. And they were providing limited licenses to laboratories that wanted to test for about 17 specific mutations known to occur in BRCA1, but not allowing anyone else to do the full gene sequencing to look for mutations anywhere through the gene. And Dr. Arupa Ganguly had to stop providing clinical BRCA1 testing at the University of Pennsylvania. This is a letter I got from the University of Michigan Medical School that holds the patent for the cystic fibrosis delta F508 mutation. And the delta F508 mutation accounts for about 70% of the mutated gene copies that are known to occur and cause cystic fibrosis. It's covered by a patent, and they were providing non-exclusive worldwide in-house diagnostic testing licensing. And so if we were providing diagnostic results to patients basically at cost, and we get reimbursed so little for what it costs us, then, or using a test kit that had a license from University of Michigan to have developed that kit, then we didn't need a license. And so if everyone was enforcing their patents the way University of Michigan did, this is a very nice model for how to enforce a patent rather liberally, widely. Anyone can get the rights to do this testing, and commercial companies may have to pay a royalty. Then I don't think I would be up here talking to you today if everyone was doing what they were doing. This was a draft license agreement between InVivoScribe Technologies, lest, Harvey, you think you're off the hook. They were exclusive licensees to 2 patents that basically covered the diagnosis and monitoring of leukemias and lymphomas by what is called B and T cell antigen gene rearrangements. So InVivoScribe was basically forced by the patent holder to take an exclusive license for the test kits that they were producing to allow laboratories to do B and T cell antigen receptor gene rearrangements that were used to determine, clonality of lymphoid cell populations and for the diagnosis of lymphoma and even monitoring of residual disease. The method has been used widely in many, many laboratories. So this came as a surprise to many laboratories when InVivoScribe started saying that we would have to take licenses. And these licenses basically required no payment for previous testing that you had done. But there was a license fee in the tens of to hundreds of thousands of dollars. I've heard various ranges, again, that gave my vice chair a giggle. I don't think Don Young would appreciate being said that he giggles, but he was laughing. And then we had to pay a per test fee that was anywhere between $0 to $60. And there was a lower amount paid if it was using the InVivoScribe kit. In fact, nothing per test if we used the InVivoScribe kit for our University of Pennsylvania patients. If we did not use the InVivoScribe kit for our patients, then it was a $40 per test fee. If it was non-University of Pennsylvania testing, so basically reference laboratory kind of testing for patients outside, using the InVivoScribe kit, it was $40 and $60 if it was not a Penn patient, not using the InVivoScribe kit. So our situation in 2002 was that we did about 200 IgH or B cell and 209 T cell tests per year. The T cell test was a lab-developed test, and the B cell test used the InVivoScribe kit. So the cost to perform each test is about $300. That's before the fee. And there was no per test fee for UPenn, University of Pennsylvania, B cell testing. So what we ended up with was about $8,000 to $10,000 per year plus the license fee. Medicare reimburses $55.39 per test. So this was not very economically feasible. So while at the University of Pennsylvania, I was stopped from doing 4 tests, or between Arupa and I, we were stopped from doing 4 tests. we negotiated agreements for cystic fibrosis, which really wasn't too onerous, and B and T cell gene rearrangements. We had notification letters for hereditary hemochromatosis and SCA1, and those enforcements basically stopped for various reasons. And we became, once the lawyers at the University of Pennsylvania became aware of this pattern of events, we started searching, they started searching for other patents that were on the tests that we were doing, and that included spinal muscular atrophy, myotonic dystrophy, and other tests that we were contemplating doing. So it's not very limited. So in my experience, exclusive licensing or patent enforcement that's exclusive creates basically a sole provider of a medical service. This eliminates competition for pricing. It reduces innovation in the test method that you can use to do the testing, which when it's done widely, people figure out better ways of doing the testing that may be more cost-effective, shorten turnaround times, etc. It also means that one provider can dictate medical practice and even limit patient access because patients may not have the right insurance or whatever. Also, most of the molecular testing that we do scientific observations because things don't always work the way we think they're going to work, and you learn more things about what the gene mutations are that can happen and what is causing the disease. And that is relegated to a single investigator. It limits education of medical students and residents and fellows. And in my opinion, it's not in the best interest of the public health to have a sole provider of a medical service. It also means that you can have unreasonable licensing practices, high licensing fees for tests with low reimbursement. There's something called royalty stacking. Well, just imagine that 20% of the human genome genes are patented, and we're now talking about having next generation sequencing of the entire genome. Can you imagine what the royalty payments would be on 20% of the genes before you've even started doing one single thing to that specimen? You're well above the $1,000 genome that we're trying to get to. So that's the issue of royalty stacking, that when you want to do more complex testing rather than a single gene test, it becomes very complicated. I've experienced limitations of testing volumes, and they can limit the use of methods that are already in clinical practice, like the B and T cell gene rearrangement testing. And control of one gene can control the testing for many genes, as I've demonstrated, and it can constrain technological advances to whole genome sequence or analysis. So that was my experience. What's been the national experience? So in 1998, John Merz, Mildred Cho, and I did a pilot survey of 74 laboratory directors, and about 50% reported that they were not offering a genetic test because of known patents on that gene sequence. And 25% had been prevented from performing a test, so they had to stop doing a test that they had previously been doing. And it suggested that there was a potential problem and that my experience wasn't unique. So we then did a national survey related to a single gene test, and that's the hereditary hemochromatosis gene enforcement that was happening around the 1999 time period, although that eventually dropped off. And so we surveyed 128 laboratories regarding hemochromatosis testing and found that so 117 of 128 of those labs were interviewed, and 30% of labs reported not starting to do the testing or having to dropping doing the testing. And 22 labs stated that the patent was the reason that they weren't doing or had stopped doing the testing, and 10 labs stated that the patent was one of several reasons. So hemochromatosis patent had inhibited genetic testing for hereditary hemochromatosis nationally. And this shows an interesting phenomenon in that these green bars are the filings of the patents, the dates of the filings of the patents of the hereditary hemochromatosis or HFE gene patents. The paper was submitted here in 1996 and published in August of 1996. And then these patents issued out here in 1998, which is when we began to experience the patent enforcement. But look at what the laboratories are doing. As soon as this paper is published, there are at least 2 labs doing the testing almost immediately, and the testing continues to increase without patent incentives. So clinically relevant information, when it is published, is taken up by laboratories that can develop the testing without any patent incentives needed to motivate them. We're motivated by wanting to take better care of patients. So is there a need for gene patents? Publication basically allows development of diagnostic testing. We have what's called prior art in the legal terms, means we know molecular biology methods. So we know how to take a sequence and develop a test that can be used diagnostically. And laboratory adaptation is quite rapid. And then the patent holder basically benefits from the market development that has happened by the laboratories starting to do this testing. Clinicians are used to having the test, and the patent holder can walk into this nicely developed market for their test and stop everybody else from doing it. And then we did a third study looking at genetic testing in general. And this was done in 2007, in which we were able to survey 132 labs that we identified either on the Gene Tests website or through the Association for Molecular Pathology membership directory. And basically what we found is that there were, again, 53% of laboratories had decided not to develop or perform a clinical genetic test because of a patent, and 25% reported having stopped performing a genetic test because of patent or exclusive license enforcement. And this extended over 12 different genetic tests that were covered by 22 patents, and each test was performed by between 1 and 9 laboratories, with an average of 4 laboratories. So patents were inhibiting clinical genetic testing. So these are the 3 studies that I talked about, in which there's about a 30 to 50% reporting of labs not doing testing somehow related to a patent or worries about a patent, and 20 to 25% of labs reporting having had to stop doing testing. So it's not a small issue. So why should we care whether gene patents are in force or not? Well, current medical genetics focuses on diseases that are caused entirely by a mutation in a single gene. And so this is classic medical genetics. You think about Huntington disease, cystic fibrosis, spinal muscular atrophy. And these diseases, while important to the families, it focuses on diseases that are relatively rare, and very few people, relative to other more common diseases, are affected. It's a small part. Medical genetics is a small part of medical practice with relatively minimal impact on society. But we are moving to the future of, whether you call it genetic medicine, personalized medicine, there are many different names, for the understanding of the human genome and all the genetic variants that are probably involved, each to a small part, in more common diseases. That we will be using the human genome to make diagnosis, to make treatment decisions, which we're already beginning to do, for therapeutic monitoring that we're doing already, eventually to provide prognostic information and maybe even develop preventive strategies. It's being used for prenatal diagnosis, pre-implantation genetic testing, and certainly for pharmacogenetics. So if you look at the leading causes of death in the United States, then 9 out of 10 of these causes of death are influenced by genetic variations. And I have accidents highlighted here, but if you think about risk-taking behaviors and things that probably are influenced somewhat by genetics, then even accidents, alcoholism, other kinds of accidents, are even related to genetic variations. So if you look at Jim Fix, 5'10", 150 pounds, he was a marathon runner, and he promoted a healthy lifestyle, and he died at age 52 of a heart attack. His father had died at age 43 of a heart attack. Contrast this with Winston Churchill, 5'8", 270 pounds, didn't exercise, smoked. Basically, I think you could have said he has an unhealthy lifestyle, and died at the ripe old age of 90. Well, this is the impact of genetics. So the future genetic medicine is that common diseases will begin to be understood as the underlying variations that interact with environment and behaviors to cause increased risk for certain diseases. And it basically includes any disease that we currently identify by family history, and many that we don't even identify by family history. It affects virtually every person and affects virtually every physician's practice. And it is my opinion that gene patents limit this future. National practice standards can be set by a sole provider, and I've gone through most of these things. There's no competition for test cost, quality, or methods. It limits medical education, medical practice, and limits broad availability of genetic tests. So again, a sole provider of a medical service is not in the best interest of the public health. So are there any solutions? Well, these are the solutions I'd like to talk about. One we'll go through really quickly, which is do nothing. So moving right along. So you can do nothing, but there are various options, and I've been working on several of these fronts. There are things that we can do in the realm of policy, or that have been done in the realm of policy, congressional, legislative potential, courts, and the U.S. Patent and Trademark Office. So there have been 3 national analyses of the impact of gene patents that I would like to mention with recommendations. The first are the NIH Guidelines on Genomic Inventions and Intellectual Property Recommendations, and these were published in the Federal Register in 2005. And the basics are that you should only patent when necessary. I don't know how quite you define that. And avoid exclusive licensing whenever possible when you do have a patent. And the Association for Molecular Pathology's response to this was, well, it's very good intentions, but it's too weak to help molecular pathology because it's just recommendations. There's no enforcement of these recommendations and no incentive to follow them. The second study was one that was done by the National Academies. It was commissioned by the National Human Genome Research Institute. And what the National Academies were asked to do was to look at DNA and protein patents and look at the patenting practices currently being used in the United States as well as in other countries. Look at the implications of these gene patents for research, industry, and the practice of medicine. And NHGRI asked for very specific recommendations of what could be done if they found any problems to correct those issues. This committee, National Academies Committee, was chaired by Shirley Tillman, who's the president at Princeton University. And it's interesting to look up at the makeup of the membership of this committee because there were 5 intellectual property lawyers, 4 professors, but not in the area of medicine, technology transfer officer, but basically there was 1 physician who was a pathologist on this committee. And their report was published in 2006, which contained 13 recommendations. And basically, because of the makeup of the committee, recommendations 1 through 11 focused on research implications. Recommendation 12 was that the court should take action if the public health is threatened. And recommendation 13 was an exemption from patent infringement, so you wouldn't be acting against a patent for independent verification of a clinical test result that was provided by a sole provider. Now, because there were very few pathologists, and the one pathologist was having problems having everybody else understand how pathology works, we would never develop a test in our laboratory for the chance that someone would want their result verified by our laboratory because we couldn't keep it working well. We wouldn't do it often enough to have the proficiency testing and everything else. Technologist training, competency, this is totally unrealistic. What's interesting is the content. The preamble to recommendation 13 states that they identified a variety of concerns, but then that recommendation 13 was the only thing that they addressed. And the concerns that they identified was potential problems with access for patients to this testing, allowing competitive perfection of the tests, facilitating professional education and training, which may be limited, and ensuring regulatory compliance by that one provider of a test. So they identified a lot of issues, but they couldn't figure out what recommendations to make and come to consensus, so they made one that wasn't really that good. So the third policy report is the Secretary's Advisory Committee on Genetics, Health and Society, or SACGHS, that did a gene patent and patient access study or analysis. And there was a small working group that was chaired by Jim Evans from University of North Carolina in Chapel Hill. And multiple approaches were used to investigate the clinical impact of gene patents. And this study was put off until the National Academy study was done because SACGHS didn't want to duplicate the efforts of the National Academy study, thinking that it was going to address the clinical issues, but they were not properly addressed. So that's why SACGHS decided to go ahead. They felt that the research issues were fully addressed by the National Academy study, but the clinical issues were not. And they commissioned case studies to be done to look at patented and unpatented tests that were fairly comparable and what the implications were for cost and access. They had a public comment process, and they even looked at international perspectives. And they provided a comprehensive report to the Secretary of Health and Human Services. This is the first national study documenting a negative impact of gene patents on patient access and medical practice. And their recommendations, and none of this has been acted on at this point, but is that there be patent exemption for diagnostic and research uses of patented genetic information, that there be advocacy for best practices in licensing, so more like what the University of Michigan did rather than what other licensing practices have been, that there's enhanced transparency in what is patented and how it is already licensed. That's particularly important for companies that are trying to follow the licensing trails to know what they can license, what areas they can license in. Federal monitoring of patient access problems, because right now it's all hearsay, word of mouth, although we do have a lot of public commentary now from this public comment period documenting patient problems due to patent enforcement, and federal promotion of broad licensing and patient access. So those are the policy areas, all nice recommendations, but no teeth as far as I can see at this point. But it sets the stage for other action that can be taken legislatively in the courts and even by USPTO. So moving on to legislative options, I hate to have these eyeballs staring at you, but they get your attention and will wake you up in the middle of the talk. So there was a cataract incision. Someone discovered that if you make a curved incision instead of a straight incision in the cornea, that it heals better. And this was patented. Well, the AMA got pretty upset and lobbied Congress for physician protection against such medical process patents. So Gansky and Frist created an amendment that was enacted in 1996 that basically protects physicians and their institutions for performance of a medical or surgical procedure on a body that infringes a patent. It excludes protection for physicians who are pathologists who perform clinical laboratory tests unless that test is performed in a physician office laboratory. So the problem is that this is very nice, but physicians like us who provide clinical laboratory testing services as their medical practice aren't protected against patent infringement lawsuits under this Gansky-Frist now law. So one legislative option is to extend this to pathologists. And there was a bill drafted by Representative Lynn Rivers that was introduced back in 2001, I believe, H.R. 3967. But I began to learn a lot about politics through this gene patenting efforts that I've been doing. And Lynn Rivers was not reelected because her district was redrawn. She wasn't reelected. It's never been reintroduced. But in the SACGHS discussions, in other discussions, this Lynn Rivers protection, extending Gansky-Frist through a Lynn Rivers type of bill is something that comes up over and over again. Another legislative option is to mandate broad and reasonable licensing, much as the University of Michigan currently does. Congress could create such a law to mandate licensing with reasonable pricing that would allow broad access and use of gene patents. Another legislative option would be just to prohibit gene patents. just get rid of them altogether. And this is a bill. This is the first part of the bill, introduced by Representative Becerra and Weldon. And it is called the Genomic Research and Accessibility Act. And it would change the law so that no patent may be obtained for a nucleotide sequence or its function or correlations or the naturally occurring products it specifies. This, as currently written, shall not apply to a patent issued before the date that this is passed into law. So this has been introduced several times. The College of American Pathologists is working with Representative Becerra. There is consideration of getting rid of this only future patents to include all existing patents. So it's not clear whether this will move forward or not. Many people see this as too extreme and that we should probably allow gene patents but just address the exclusive licensing issues. So those are various legislative options that are out there and being discussed. There is also the courts. So this is one court case. A company called UPI was issued a patent in 1986 that claimed a method. So this was a method. So this isn't a gene patent, but it relates to what could be done in the courts for gene patents. It's a method for measuring total homocysteine levels. But that's claims 1 through 12 that describes the steps that you do to make that measurement. And nobody has too many problems with that method type of patent. Claims 13, though, claims a method for detecting a deficiency of cobalamin or folate in warm-blooded animals, such as humans, comprising the steps of doing the test described in claims 1 through 12, and then correlating homocysteine elevation with a deficiency of cobalamin or folate. So it is claiming a thought process. So UPI licensed this patent to Metabolite Laboratories, and Metabolite sub-licensed this to LabCorp. And LabCorp paid the royalties to Metabolite, and LabCorp then developed a better method for measuring homocysteine levels and stopped paying their royalties. So Metabolite sued LabCorp for infringement, and because of that claim 13, because they were still doing that correlation even if they were using a different testing method. LabCorp sued Metabolite over claim 13. So everybody's suing everybody, I know, don't get confused. But LabCorp lost and appealed to the Supreme Court. When the Supreme Court takes a case, I never knew this, but the Solicitor General sometimes comments, or always comments, is it always or sometimes, comments about whether the Supreme Court should take a particular case. And the Solicitor General recommended against taking the case because he thought the implications were too great for biotechnology and would really mess things up. But the Supreme Court decided to take the case in 2005. The question heard by the Supreme Court was whether a patent instructing a party to correlate test results can validly claim a monopoly over a basic scientific relationship used in medical treatment such that a doctor infringes the patent by looking at a test result and thinking about that relationship. The problem with this in the Supreme Court was this was not the question that had been argued in the lower courts. So there were different questions argued in the lower courts. And this is the very short decision from Alito, Ginsburg, Kennedy, Scalia, and Thomas that the writ of certiorari, I don't know how to say that, is dismissed as improvidently granted. What that means in English is they hadn't argued it in the lower courts, so the Supreme Court was not going to make this decision. But Supreme Court Justices Breyer, Souter, and Stevens felt strongly enough that they wrote an entire dissenting opinion, which I wish I could have written myself. So I'm going to read you parts of this. The relevant principle of law excludes from patent protection laws of nature, natural phenomena, and abstract ideas. The justification for the principle does not lie in any claim that laws of nature are obvious, or that their discovery is easy, or that they're not useful. To the contrary, research into such matters may be costly and time-consuming. Monetary incentives may matter. And the fruits of those incentives and that research may prove of great benefit to the human race. Rather, the reason for the exclusion is that sometimes too much patent protection can impede rather than promote the progress of science and useful arts, the constitutional objective of patent and copyright protection. One can reduce any process to a series of steps. The question is what those steps embody. And here, aside from the unpatented test, they embody only a correlation between homocysteine and vitamin deficiency that the researchers uncovered. They didn't invent it. That's my editorial comment. In my view, that correlation is an unpatentable natural phenomenon. I can find nothing in Claim 13 that adds anything more of significance. And this is the last quote from the decision. If I am correct in my conclusion that the patent is invalid, then special public interest considerations reinforce my view that we should decide this case. To fail to do so threatens to leave the medical profession subject to the restrictions imposed by this individual patent and others of its kind. Those restrictions may inhibit doctors from using their best medical judgment, force doctors to spend unnecessary time and energy to enter into license agreements, divert resources from the medical task of healthcare to the legal task of searching patent files, I've experienced that, and raise the cost of healthcare while inhibiting its effective delivery. So I liked all of that. So there's another case that's relevant to gene patents, though not directly on a gene patent, which is a Bilski versus Kappos, which questions the validity of association process patents. And this may call into question the correlation between gene variants and clinical disease or what are called phenotypes. This case is currently pending in the U.S. Supreme Court. Some justices have expressed skepticism about overreaching patents, including this Bilski type of patent, and it's predicted that it's unlikely the Bilski patent will stand. It probably will be overturned, but we are waiting for that decision. There's another case of Prometheus versus Mayo, in which Prometheus licensed an association patent correlating thiopurine metabolite levels with drug activity or side effects. Prometheus sued Mayo for infringement. Mayo won, and then the court ruled basically the patent claims unpatentable natural phenomenon. The Court of Appeals for the Federal Circuit reversed the lower court's decision, said it was patentable, and this has now been appealed to the U.S. Supreme Court. And then there's a more recent case of AMP, Association for Molecular Pathology et al., versus the U.S. Patent and Trademark Office et al. The plaintiffs in this case were represented by the American Civil Liberties Union, ACLU. There were 4 organizations, including AMP, 6 physicians or PhDs, 2 genetic counselors, patients, and patient organizations. And the defendants were Myriad Genetics, University of Utah Research Foundation, and the U.S. Patent and Trademark Office. And what they were claiming were the BRCA 1 and 2 specific patent claims, and the question being asked is, are isolated human genes and the comparison of their sequences patentable? They also brought constitutional freedom of speech and privacy claims against the U.S. Patent and Trademark Office. This was because they felt that even if these gene patents were overturned, the USPTO could continue to grant gene patents, and they didn't want the patenting of gene sequences to continue. So this was heard in January, and the decision was filed on March 29th, 2010, just of this year. So Myriad, in the arguments presented to the court, argued that the USPTO had granted them the gene patents and Congress hadn't acted to stop gene patenting, and the court basically said, so what? There are many patents that get overturned. Doesn't matter that Congress hasn't acted to stop gene patents. They are the courts, and they can make their own decision. And as to the question of are isolated human genes and the comparison of their sequences patentable, the court decided no, they are not. It's interesting, they distinguished between an invention and a discovery. And this, they felt, was simply a discovery, uncovering a natural phenomenon. The purpose of DNA is to carry information. And they felt that DNA is not just a chemical substance, that it has informational content. And that informational content is valid whether it is in the nucleus of a cell or is purified in its purest form, isolated form, in a test tube. And that informational value isn't changed in the purification process. It is a very sophisticated decision that understands a lot of molecular biology. So the next steps, this will more than likely be appealed to the Federal Circuit. And if you remember in one of the previous ones, the Federal Circuit overturned a decision. And the Federal Circuit is likely to overturn this decision because they don't like to make big decisions that have huge implications. Biotech is very worried about what would happen, but then it's likely to then be appealed to the Supreme Court. So you have to come back and see the next stages of this one. And then there's the USPTO. So in AMP versus the USPTO, there was constitutional freedom of speech and privacy claims against the USPTO. What I didn't understand is that the courts are constrained by what's called a doctrine of constitutional avoidance, which basically means that you do not make constitutional decisions unless you absolutely have to. And in this case, they were able to overturn the claims without doing this constitutional aspect against the USPTO. And what they stated in the last pages of their decision is that their decision of invalidating gene patents basically would mean that the USPTO would have to conform its policies to be consistent with court decisions. And so they felt that this would be binding on the USPTO as well. So to conclude, I guess you know where I'm going to come down, but incentives or inhibition. So gene patents are incentives to stimulate biomedical research, although I would argue that the vast majority of gene patents are held by academic medical centers. And we don't really need the incentives of gene patent protection to do those discoveries because our motivation is to help patients understand diseases, be able to diagnose them and treat them better. But there is monetary gain for academic medical centers and the protection for downstream drug and biomedical development. The inhibitions, I think, have been fully discussed. It restricts diagnostic testing or other clinical testing, constrains medical practice and education. It can increase healthcare costs, limit patient access to this newer testing. It may inhibit research and raises moral and ethical concerns. So some philosophical questions that I will leave you with, and you can use them for points of discussion. Should gene patents even be granted? I think that the AMP versus USPTO has said no, so I won't discuss this one very much. Do gene patents inhibit or promote the progress of science and useful arts? And in this case, I would like to focus on medical practice. And I don't know that they promote medical practice. Are patent incentives needed for discovery or clinical use of genetic information? I think some of the research that was done looking at the hemochromatosis gene uptake without any patent incentives shows that the patent incentives really aren't necessary for medical application of this information. Should exclusive licensing of fundamental medical knowledge be allowed? And finally, is sole ownership of a disease in the best interest of the public health? And I would argue that it is not. So thank you very much for your attention, and I'd be happy to take questions. So any questions? Yes?
Thank you for a wonderful talk. Have you or have the organizations that you've worked with looked into the internal politics of universities and medical schools for how investigators who made these discoveries feel about these processes as opposed to the business offices and patent offices and licensing offices of the same universities?
So the question being asked, I have to repeat this because we have remote listeners, is have the organizations that I work with talked with the discoverers, the researchers, the physicians who make these discoveries versus the technology transfer officers and business people within academic medical schools? Yes, somewhat. I haven't so much as talked with the investigators, although I've spoken with Mary Claire King about her feelings. I think you probably all know those. But I have spoken to the technology transfer officers. So I was on a panel just this spring at the Autumn meeting, which is the Association of University Technology Managers. I think that's what Autumn stands for. And it was a very heated panel discussion with opposing opinions and how the world was all going to fall apart if we get rid of gene patents. And I was on obviously the other side. So the technology transfer officers were encouraged at that meeting to talk to the investigators, the patients, and the physicians who take care of patients who have the particular disease that would be affected by the gene patent about how they feel that things should be licensed. And many family organizations or family disease organizations are beginning, when they participate in research, to ask as a condition for participating in the research that they be named on the patent so that they can help control how that patent is licensed and used. So I think the world is changing. I think that because of Bayh-Dole, there was a lot of licensing without experience of licensing this type of medical information, that when you have a patent on gene sequence, it really kind of patents that disease almost, when it's a single gene disease. So I think it's evolving. And I think researchers are beginning to understand more of the implications, as well as the tech transfer officers, about the licensing practice and the impact on medical practice and patient access. So another question?
Are there patent expirations, as in, like in the pharmaco world, they have expirations?
So the question is, do patents expire? And yes, they do. And it's 20 years from the time of filing now. I think that's correct. But it's around 20 years, which is a really long time in the discovery realm of what we're learning about the human genome. So, but yes, they will expire. What is true usually is that the first patent is the first patent to usually a series of patents that issue. So that 20-year time frame is actually extended from the first patent to 20 years from the latest patent being able to control those sequences.